The only explicit limitation on an inspector general's authority to conduct audits and investigations within its jurisdiction resides in Section 8E of the Inspector General Act. Section 8E is an extraordinary exemption that provides the Attorney General with the authority in carefully circumscribed circumstances to prohibit the Office of Inspector General from carrying out an audit or investigation. To invoke Section 8E, the Attorney General must explain the reason for his decision in writing and make a determination that a limitation on an IG's exercise of authority is necessary to prevent the disclosure of certain specifically described categories of information or to prevent significant impairment to national interests. My question to you is, has Attorney General Holder at any time during your tenure used this formal procedure to limit your office's access to material essential to a review?
He has not, and that's been one of the arguments we've put forward, which is that's the mechanism Congress set up to limit our access if there are sensitive matters. That's the provision that should be used, not simply a standing objection to our access.
In your experience, prior to your troubling experiences with the 3 reviews that you cite in your testimony, had any Department of Justice component ever asserted the right to make unilateral determinations about what requested documents were relevant to an Office of Inspector General review?
To my understanding from speaking to my predecessors and others in the agency, that had not happened before 2010.
How valuable is your authority to access grand jury or other sensitive material to your ability to execute rigorous oversight of national security matters?
It is critical, Mr. Chairman. These are the tools of the trade for the FBI, other law enforcement agencies. If we can't access every piece of information in their files when we're doing oversight of the FBI's use of these tools in its handling of various national security tools, we won't know the full answer to what's going on.
And according to your office, the FBI's withholding of the grand jury information is unsupported in law and contrary to both the Inspector General Act and exceptions to the general rule of grand jury secrecy. Would you outline the 3 reasons why the Office of Inspector General is entitled to access grand jury material that the FBI claimed was privileged?
Yes. Certainly, first and foremost, Section 6A of the Act could not be clearer, as Congressman Conyers just outlined in his opening statement. It is crystal clear. That's the primary reason. But secondarily, under the grand jury rules, prior to 2010, we had regularly obtained grand jury material because we have attorneys for the government working for us. I'm an attorney. We have a number of attorneys working on our staff. That would be the other exception. And then third, in the national security area, there's an additional exception in the grand jury rules that had, before 2010, been used to get us grand jury material. So there are at least 3 reasons why we should be getting this material.
You testified earlier that at no time has the Attorney General complied with Section 8E and given you testimony or a statement in writing as to why material would not be provided. Have you had the opportunity to have any verbal discussion with either he or the Director of the FBI as to why they are choosing not to make this material available to you?
I have. I've raised my concerns with both of them, and the response from the Department has been most recently to send the matter to the Office of Legal Counsel to evaluate the FBI's competing legal argument, and that is where the matter currently lies and has for several months now, and it's very important that that opinion be issued. I think it should be clear that we are entitled to it, but if there is going to be a contrary ruling, we want to know it sooner rather than later so that we can fix the problem and work with the Congress to fix the problem.
Have there been any previous opinions put forward by the Office of Legal Counsel with regard to this issue?
There have, and that again is one of our points, which is in 1984, prior to our existence, which we came into existence in 1988, OLC issued a legal opinion finding that the Office of Professional Responsibility was entitled to access grand jury information. We are at a loss to understand why that same opinion wouldn't apply to us, given we have the same oversight responsibilities, and on top of that, unlike with OPR, Congress, again, as Congressman Conyers quite clearly laid out, found that we should be getting these materials and put a provision in law that says that.
Thank you very much.